dare you close this road? We have a right to be here.
Not anymore, you don't. I hold the deed and the keys. Now get out!
I've made that drive since 2018. I-40 west out of Charlotte, 321 north into Watauga County, then the county roads climbing into the high country. I know it by landmarks. I know every curve of Ridge Run Lane, all 1.7 miles of it, from the county highway to my driveway. Private road, private land, private house. The mountain in January, the bare hardwood ridgeline, the creek running beside the road. I came around the final left curve at 3:28 p.m., and the motion sensor light was on. It activates at dusk. It was mid-afternoon. Something had triggered it in the past 20 minutes. There was an unfamiliar car in my second bay. The front porch light was on. I never leave the front porch light on. I walked to the front door and put my key in the lock. The key didn't turn. Someone had changed my lock. Through the side lights I could see into the entry hall. A coat rack that wasn't mine. A lamp that wasn't mine. Furniture that wasn't mine. Arranged, lived in use. Someone was living in my house. I walked back to my truck, made 3 calls. Then I drove to the bottom of Ridge Run Lane and parked across the only road out. I spent 25 years as a federal prosecutor. I know when someone's about to run. Before we dive into the story, comment where you're watching from and make sure you're subscribed for more stories like this. I bought the Watauga County property in 2018 for the specific reason that it was at the end of a road. 25 years as a federal prosecutor in Charlotte produces a particular relationship with solitude. Not antisocial, not reclusive, but a precise understanding of the difference between chosen quiet and imposed noise. The mountain house was chosen quiet. 18 acres on a Watauga County ridge, 4,800 square feet of timber frame construction, a wraparound porch facing west toward the Blue Ridge, at a sightline that had no other structures in it. And Ridge Run Lane, 1.7 miles of private gravel road from the county highway to my driveway, entirely on my deeded property, with no other properties served by it. Private road, private land, private house, the kind of property that a retired federal prosecutor understands in legal terms as clearly as he understands it in practical ones. What's mine is documented, recorded, and unambiguous. I've been making the drive up from Charlotte since 2018, spring visits and fall visits primarily. The mountain in April when the rhododendron comes in, and in October when the hardwoods turn and the ridge catches the afternoon light in a way that I haven't seen anywhere else in 40 years of living in North Carolina. Occasional winter visits when I wanted the specific quality of a Watauga County mountain in snow. A summer trip most years. The house was maintained by Dale Hutchins between visits, a property manager I'd hired in 2019 who lived in Boone, checked the property monthly, handled contractor coordination, and kept me informed about anything that needed attention. A good arrangement, functioning smoothly for 5 years. I'd last been at the property in September 2024. The plan was a January visit. A week, maybe 10 days, the winter ridge, the quiet. I'd told Dale in December that I'd be coming up the second Friday of January. He'd confirmed the heat was running, and the driveway had been cleared after a December snowfall. What he had not told me, what he could not have told me, because he didn't know, was what had happened to the property in the 11 weeks between his last check in early October and my January arrival. The drive from Charlotte to Watauga County takes approximately 2.5 hours on a clear day. I-40 west to 321 north, then the county roads up into the high country, where the elevation climbs and the temperature drops, and the landscape changes from the Piedmont to something older and more deliberate. I know the route by the landmarks rather than the mile markers. The Lenore exit, the turn at the Caldwell County line, the point where 321 starts climbing, and you can feel the altitude change in the way the engine responds. I turned onto the county road that connects to Ridge Run Lane at approximately 3:15 p.m., January in Watauga County. The bare hardwood ridgelines, the sky a flat pale winter gray, the creek audible through my cracked window, the same creek that runs along the east side of Ridge Run Lane for its first half mile from the county highway. I've been listening to that creek on this approach since 2018. It was part of the arrival. The turn onto Ridge Run Lane at 3:20 p.m. The lane is gravel, 1 lane wide, with passing pull-offs at 3 points along its length. It runs north from the county road through a section of mixed hardwood and hemlock, crosses the creek on a timber bridge at the 0.6 mile mark, climbs the ridge through a series of switchbacks, and arrives at my driveway entrance at the 1.7 mile mark. The house is visible through the trees from the road as you come around the final left curve at the 1.4 mile mark. I know every foot of that road. At the 1.4 mile mark, I came around the left curve and saw the house through the trees. The motion sensor light at the driveway entrance was on. I noted it with the specific attention of someone whose professional training included noticing things that were slightly wrong. The motion sensor light was programmed to activate at dusk, approximately 5:15 p.m. in January in Watauga County. It was 3:28 p.m. The light was on because something had triggered the motion sensor recently. Something moving at the driveway entrance in the past 15 to 20 minutes. I pulled into the driveway slowly. An unfamiliar car was parked in the second bay. A silver Subaru Outback with Watauga County plates that I had never seen before. Not a contractor vehicle, not a delivery vehicle, not anything associated with Dale's maintenance work. A personal vehicle, parked with the casual permanence of something that had been there for a while. The front porch light was on. I never left the front porch light on. I sat in my truck in the driveway for a moment. Then I got out, walked to the front door, and inserted my key. The key didn't turn. I applied moderate pressure. Nothing. The key was entering the cylinder correctly. The cuts were engaging. But the cylinder was not the same cylinder. The key fit the keyway but not the specific pins. Someone had changed my lock. I stood at my own front door and processed that fact. Through the side lights flanking the door, two narrow vertical windows, original to the timber frame construction, set into the door surround, I could see the entry hall. A coat rack that wasn't mine. 4 or 5 coats hanging from it. The kind of personal, everyday coats that accumulate on a rack that's in regular use. A lamp on the entry table that was not my lamp. A different base, a different shade, positioned differently than my lamp had been. And beyond the entry hall, visible through the open doorway to the living room, furniture arrangement that was not my furniture arrangement. Someone was living in my house. I am not a man who reacts to surprises with visible emotion. 25 years of federal prosecution does not produce people who display their internal states at inconvenient moments. It produces people who separate the fact of a situation from their response to it, assess the fact accurately, and act on the assessment rather than the emotion. I walked back to my truck, sat in the driver's seat, made 3 calls. The first call was to James Whitfield. James had been my property attorney in Charlotte for 9 years. He'd handled the Watauga County purchase in 2018 and had done subsequent work on boundary issues and easement documentation. He was also, by training and early career practice, a criminal defense attorney who had moved to property law in his 40s. The combination made him useful for situations that crossed both categories. He answered on the second ring. James, I'm at the Watauga County property. Someone has changed my locks and is living in my house. A pause. Not a long one. James processed unusual information quickly. Are you inside? No, I'm in my truck in the driveway. The key doesn't work. I can see through the side lights. Different furniture, personal belongings. Don't attempt entry. Call the sheriff's department now and call me back after you've spoken with them. Do not speak to whoever is inside before the sheriff arrives. A pause. Victor, do you know who it is? Not yet. Call the sheriff. I'll start pulling the property records to have the ownership documentation ready. You're going to need it on site. Second call. Watauga County Sheriff's Department non-emergency line. I explained the situation to the dispatcher with the concision of someone who has spent a career communicating facts to people who need to act on them. I was the owner of record of the property at the end of Ridge Run Lane. I had arrived to find my locks changed and an unauthorized occupant in residence. I was requesting a deputy respond to the address. Estimated response time, 35 minutes. A deputy was in the area, but finishing another call. 35 minutes. Third call, Dale Hutchins. He answered on the 4th ring, his voice carrying the particular quality of a man who has been managing a difficult period. The voice of someone who is getting by, but not well. Dale, when did you last check the Watauga property? A silence. The silence of a man who has just been asked a question, whose answer is going to be very bad. Victor. He stopped. Early October. I've been dealing with my father. He's been in the hospital since October 12th, and Another stop. I should have called you. I should have arranged coverage. I didn't. I kept thinking it would be a week, 2 weeks. I'm sorry, Victor. 3 months. The property had not been checked since early October. Dale, in November, did anyone contact you about the property? Ask about the vacancy schedule? Another silence, longer. There was a call, end of October, maybe first week of November. Someone said they were from a maintenance company, asked if the property was going to be occupied through the winter. I said you usually didn't come up until January. He paused. Victor, who's in the house? I don't know yet. The sheriff is on the way. I ended the call, sat in the truck, 35 minutes. I thought about what I knew. Someone had called Dale in late October or early November, established that the property would be vacant until January, and had then, at some point between that call and the present, entered the house, changed the locks, and moved in. Not vandalism, not a break-in for theft, The lights were on and managed. The car in the driveway was a personal vehicle. The coat rack in the entry hall had everyday coats on it. The furniture visible through the side lights was lived in, arranged, in use. This was occupancy. Someone had moved into my house. I got out of the truck, walked to the driveway entrance, looked down Ridge Run Lane disappearing into the winter tree line, the gravel road curving south through the bare hardwoods, 1.7 miles to the county highway. One road. My road. Documented, deeded, the full 1.7 miles on my recorded property. One way in, one way out. I got back in the truck, drove to the bottom of Ridge Run Lane, positioned the truck across the road at the county highway junction, nose into the left shoulder, tail into the right, blocking the full lane width, and set the emergency brake. Then I called James back. Sheriff is 35 minutes out. I've blocked the road. Good. Stay at the truck. Don't go back up until the deputy is with you. A pause. The ownership documentation is pulled. Deed recorded March 15th, 2018. Property taxes current. I can see the November 2024 payment in the county records. Your name is the only name on the deed. I know. Victor. Do you have any idea who it is? I thought about the adjacent property. The Blue Ridge Summit Community Association, whose eastern boundary fence I could see from my west-facing porch. The HOA president, whose name had come up twice in conversations with Dale over the past 2 years. Once, when she'd asked Dale whether I'd be interested in selling, and once, when Dale had mentioned she'd been telling neighbors that the Ashworth property was wasted on someone who's never there. I have a reasonable suspicion, I said. Don't act on it until the deputy arrives. I know how to wait for law enforcement, James. A pause. Then, with the slight warmth of a man who has just remembered who he's talking to. Right. Sorry. I sat at the bottom of Ridge Run Lane with the emergency brake set and watched the county road. The January mountain light was going, the flat gray darkening toward early dusk, the ridgeline above me becoming silhouette, the creek beside the road moving steadily, indifferent to the situation. 35 minutes. I waited. Victor Ashworth arrived at his mountain home on a Friday afternoon in January to find the locks changed, an unfamiliar car in his driveway, and someone else's furniture in his entry hall. He'd been away 4 months. In that time, Connie Marsh, HOA president of the adjacent Blue Ridge Summit Community Association, had entered his home, changed the locks, moved in her belongings, and been living there for 11 weeks. Victor called his attorney, called the sheriff, and parked his truck across the only road out. Connie had one way to leave. She didn't know yet that it was blocked. The deputy's name was Garrett Souls. He pulled up to the bottom of Ridge Run Lane at 4:11 p.m., 33 minutes after my call, 2 minutes ahead of the estimate. I moved my truck out of the road as he approached, pulled it onto the county road shoulder, and walked to his window. I gave him the facts in sequence. My name, the property address, my ownership of record, my arrival today, the changed locks, the occupied house, the unknown vehicle in the driveway. I gave him James's confirmation that the deed and tax records were current in my name. I handed him a printed copy of the deed that James had emailed to my phone, and I'd sent to a print shop on my way up, a habit from 25 years of preparing for situations where documentation matters. He looked at the deed, looked at me. You have ID? I gave him my license. He compared the name, handed it back. Let's go up. We drove Ridge Run Lane in convoy. His cruiser first, my truck behind. The 1.7 miles through the bare winter hardwoods, the creek bridge, the switchbacks, the final left curve. My house appearing through the trees with the driveway light still on, and the silver Subaru still in the second bay. We parked, walked to the front door together. I knocked. The pause before the door opened was approximately 8 seconds. The pause of someone who was not expecting a knock and was deciding how to handle it. The door opened. Connie Marsh was 55, trim, with the composed bearing of someone who has occupied a position of community authority for long enough that composure has become her default register. She looked at Deputy Souls, then at me, then back at Souls. Her expression did not collapse. It shifted, a recalibration, the composure holding but reorganizing itself around a different set of facts than she'd been operating on. Ms. Marsh. I said her name because I'd recognized her. I'd seen her twice at the boundary fence over the years, once when she'd asked Dale about the property sale, once at a distance from the porch. She was not a stranger. She was my neighbor. She was standing in my entry hall. Mr. Ashworth. Her voice was even, almost administrative. I want to explain the situation. Ma'am. Deputy Souls stepped forward slightly, not aggressively, but with the specific positioning of a deputy who is taking control of a scene. Do you own this property? The property has been vacant for. Do you own this property? She looked at him. No, she said. but the community has an interest in, "Ma'am, I need you to step outside, please." What followed was the conversation that Deputy Souls conducted on my front porch, while I stood to the side and let law enforcement do what law enforcement does. Connie's position, delivered with the calm of someone who had clearly rehearsed it. The property had been vacant since September. She had observed it going unmonitored for months. As president of the adjacent homeowners association, she had a community safety obligation. Vacant properties in mountain communities attract vandalism, wildlife incursion, and liability risk. She had taken steps to secure and maintain the property in the owner's absence. She had intended to contact the owner when his January visit approached. Deputy Souls. "When did you enter the property?" Connie. "Early November, the first week." "How did you enter?" A pause. "The door was unlocked." I knew this was false. Dale had a key, and Dale's protocol was to lock everything. But I said nothing. That was a detail for James and for the investigation. "And the locks?" Souls gestured at the door. "These aren't the original locks. I had them changed for security purposes. There was no working lock on the... You change the locks on a property you don't own." Her composure held, but the administrative calm was developing stress fractures. "I was securing..." "Ma'am, I'm going to need you to wait here." He turned to me. "Mr. Aldridge, I'm sorry, Mr. Ashworth, can we walk through the property? That's why I'm here." I walked through my house for the first time in 4 months, with a Watauga County deputy behind me and a phone camera in front of me. The entry hall, Connie's coat rack, her lamp, a small decorative table that wasn't mine with a dish on it containing her keys and some loose change. The living room, her sofa where my sofa had been. My sofa moved against the far wall, pushed aside to make room. Her coffee table, her throw blankets on the furniture. The fireplace. I stopped at the fireplace. A cord of firewood stacked in the alcove beside it. Ash in the grate from recent use, still with the faint warmth of a fire that had been burning in the past 48 hours. My fireplace tools in place. Used. I photographed the fireplace from 3 angles. The master bedroom. Her bed, her bedding, her dresser, her personal items on the nightstand. My bedroom furniture. The bed Margaret and I had bought for this house. The dresser we'd brought up from Charlotte. Moved into the guest room. Consolidated. Pushed together to make space for hers. She had moved my furniture out of my bedroom to make room for her own. I stood in the doorway of my master bedroom for a moment. Then I photographed it systematically and moved on. The kitchen. Her cookware on my shelves, intermingled with mine. Her food in my refrigerator and pantry. A coffee maker that wasn't mine on the counter. Back through the house, noting everything. The deputy was behind me, writing notes in his field book. I found the original locks in the kitchen trash can. All 4 deadbolt cylinders, cut from the door hardware and discarded. The cuts were clean, a locksmith's work, not a forced entry. Someone with tools had removed my locks and replaced them. The cylinders were in the trash, like discarded batteries. I photographed them in the trash can. Then I photographed them individually, placed on the kitchen counter with my hand in frame for scale. The security cameras, 4 units, exterior, mounted to my walls with 2-inch hardware screws driven directly into the timber frame exterior. Her cameras, on my walls, recording my property, and presumably transmitting to her phone or a storage device she controlled. I photographed each mount, each screw point. The internet router, a different unit than mine, connected to my home's Ethernet infrastructure. When I checked the service account on my phone, I was still the billing account holder. I found that the service address had been transferred to a different name, Connie Marsh, at my address. She had transferred my internet service to her name. In the mudroom off the kitchen, 17 cardboard boxes in a neat stack, all bearing a delivery service label, all addressed to Connie Marsh at my address. 11 weeks of package deliveries, received at my house, to a name that had no legal connection to my address. I photographed the stack, counted the boxes, 17. By the time I'd finished the walkthrough, I had 89 photographs. Every room, every item that wasn't mine, every alteration to my property documented with the systematic thoroughness of someone who has spent 25 years preparing evidence packages. Deputy Souls reviewed his notes on the porch. "Mr. Ashworth, I'm going to be honest with you. This is an unusual situation, and I want to handle it correctly. The changed locks, the occupancy, the transferred internet account. That's going to require me to file a detailed report and get my sergeant involved. What I can do right now is require her to vacate. That's what I want right now," I said. "The rest can follow." He went to Connie on the porch. She was given 2 hours to remove her personal belongings under his supervision. She spent the first 40 minutes of those 2 hours not moving her belongings. She stood on my porch and argued. The property was at risk without her presence. The owner was rarely here. The community had a legitimate safety interest. She had invested significant effort in maintaining the property over 11 weeks. Removing her would leave the property vulnerable again. Deputy Souls listened to approximately the first 10 minutes of this with professional patience. By minute 20, his responses had shortened to single words. By minute 30, he had stopped responding entirely and was simply watching her with the particular expression of a law enforcement officer who has given a reasonable amount of time to an unreasonable position and is now counting down. At minute 41, he said, "Ma'am, you need to start moving your belongings to your vehicle right now, or I'm going to change the nature of this interaction." She started moving her belongings. It took another 40 minutes to load her car. The bedding, the personal items from the bedroom, the kitchen items she claimed, the coffee maker, the throw blankets. The sofa and dresser and larger furniture she'd brought in remained because they weren't going to fit in a Subaru Outback, and the deputy had made clear that the removal order applied to her leaving, not to every piece of furniture being extracted tonight. The larger items would be addressed through the legal process. Her security cameras were removed from my walls before she left. Deputy Souls had been clear that she could not leave recording equipment on a property she was being removed from. She carried each camera down from its mount and loaded them into the back of the Subaru. The hardware screw holes remained in my timber frame exterior. At 6:43 p.m., she drove down Ridge Run Lane. I stood on my porch and watched the taillights disappear around the first curve. I changed the locks that night. 3 deadbolts, front, rear, and the mudroom entry, from a hardware store in Boone that I'd called ahead to confirm was open. A door bar on the front door, and a security camera system from my own phone account, mounted where I chose to mount them, recording to my own storage. I called James at 9 p.m. with the full report. He listened without interrupting. "The internet transfer is important," he said. "She used your address to transfer a utility service to her name. That's identity fraud under North Carolina law, not just a trespass issue." "I know." "The locksmith work, the original cylinders in the trash. She didn't pick the lock. Someone with tools removed them cleanly. I want to know who she hired." "Dale called," I said. He remembered the call in November, someone from a maintenance company asking about the vacancy schedule. He confirmed the property was unoccupied through January. "What maintenance company?" He didn't catch the name, but he described it as a company he'd heard of in the area, not one of his usual contacts. James was quiet for a moment. "Blue Ridge Summit uses a local contractor for their HOA maintenance work, Ridgeline Property Services, out of Boone. I'm going to pull their business registration tomorrow and run their contractor license." "You think she used the HOA's contractor?" "I think she used the HOA's contractor, billed it to the HOA's account, and called it a community safety measure." He paused. "Victor, how long has she been watching your property?" I looked out the rear window of the house, the dark ridge line, the Blue Ridge Summit fence line just visible at the western edge of my property. Dale mentioned her twice in the past 2 years. She asked him about a sale in early 2023. She made a comment, he related to me, about the property being wasted on someone who's never there. "When did she make that comment?" "Late 2023. He said she'd been saying it to neighbors." James was quiet again. "She planned this," he said. "This wasn't opportunistic. She was waiting for a window." I thought about the call to Dale in late October or early November, establishing the vacancy schedule, confirming I wouldn't be back until January. 11 weeks. She had given herself 11 weeks. "James," I said, "build the full case. Everything. The entry method, the HOA contractor, the authorization she used to justify it, all of it. I want the complete picture before we decide what to file. I'll have a preliminary assessment by Monday." I ended the call and sat in my living room, her sofa still against the far wall where she'd pushed mine, my furniture back in its approximate positions but not quite right. The room carrying the specific wrongness of a space that has been lived in by someone who had no right to live in it. 11 weeks. I was a federal prosecutor for 25 years. I knew exactly how to build a case. James called me Monday morning with the preliminary assessment. He'd spent the weekend pulling records, Blue Ridge Summit's HOA filings with Watauga County, Ridgeline Property Services business registration and contractor license, the HOA's maintenance account records, obtained through a combination of public filing requirements and a direct request to the 2 board members who had already made contact with his office. "Start with the contractor," I said. "Ridgeline Property Services, general contractor license, Watauga County, registered 2009. They've been the Blue Ridge Summit HOA's primary maintenance contractor since 2016. Standard arrangement, seasonal maintenance, common area work, emergency callouts." He paused. On October 28th, Connie Marsh called Ridgeline's owner, a man named Terry Bosch, and instructed him to secure a vacant neighboring property as a community safety measure. She called him directly. Directly. Not through the HOA management process, not through a board vote, not through any documented authorization procedure. A direct call from the HOA president to the contractor she'd been working with for 8 years, instructing him to perform work on a property the HOA had no connection to. And Bosch did it. Bosch did it. He contacted a locksmith, a Boone area service called Mountain Lock and Key, on October 31st. The locksmith opened Victor's front door using standard non-destructive entry tools and invoiced Ridgeline $340 for the service call. Ridgeline bundled the locksmith charge into their November HOA maintenance invoice, which was paid from the Blue Ridge Summit operating account on November 8th. I thought about the original lock cylinders in my kitchen trash can, the cleaned cuts, a professional locksmith's work. The authorization document, I said. This is the part that matters most. Papers. Connie had prepared a one-page document before she called Bosch. She titled it Emergency Property Security Authorization. Her own title, her own format, typed on Blue Ridge Summit Community Association letterhead that she had access to as president. He paused. The document stated that the Blue Ridge Summit Community Association, acting under its authority to maintain community safety and protect adjacent property values, was authorizing Ridgeline Property Services to secure the vacant residential property at the Ashworth Ridge address. It cited a provision from the Blue Ridge Summit CC&R, Article 9, Section 4, which covers the HOA's authority to address nuisance conditions within the community. Article 9, Section 4 applies to properties within the community. It applies to member properties within the Blue Ridge Summit development. Your property is not a member property. Your property is not within the Blue Ridge Summit development. Your property shares a fence line with the development's eastern boundary. That's the entirety of the connection. He paused. There is no provision in the Blue Ridge Summit CC&RS, bylaws, or any governing document that authorizes the HOA to take any action on adjacent private property. None. The authorization document Connie wrote has no legal basis in any instrument she could legitimately cite. She fabricated an authority she didn't have. She cited a real document provision and misapplied it to a situation it explicitly doesn't cover. Whether that's fabrication or willful misreading is a question the DA will characterize, but the effect is identical. She produced a document that appeared official, used it to authorize a locksmith to open your front door, and then moved into the house. Frank Doss and Linda Park had resigned from the Blue Ridge Summit Board on November 14th. James had spoken with both of them by Sunday evening. Frank Doss had been on the board for 3 years, a retired contractor from Boone who had joined the board because he understood construction and maintenance issues and thought he could be useful. He'd been receiving the HOA's monthly financial summary reports when the November invoice from Ridgeline Property Services had arrived with a line item he didn't recognize. Emergency Property Security, adjacent parcel, $340. He'd called Terry Bosch directly. Bosch had explained the situation, the call from Connie, the authorization document, the locksmith work on the neighboring property. Frank had pulled the authorization document from Connie's HOA files and read Article 9, Section 4. Then he'd read it again. He'd called Linda Park. Linda Park was a property attorney who had joined the board 2 years earlier, retired, Boone area, brought in specifically to help the HOA navigate a boundary dispute with a neighboring landowner. She had read the authorization document, read the CC and RS, and called Connie the same afternoon. Connie's response, according to Linda's account to James, calm, certain, and entirely unapologetic. The neighboring property was vacant and at risk. The community had an interest in adjacent property values. The HOA president had authority to act in the community's interest. The authorization was appropriate. Linda had told her it was not appropriate, specifically that Article 9, Section 4 applied to member properties, that the HOA had no authority to authorize entry to a private non-member property, and that what she had authorized constituted breaking and entering under North Carolina law. Connie's response: "I'll handle the legal questions. I've been president for 6 years." Frank and Linda had submitted their resignation letters on November 14th. The letters cited a pattern of unauthorized unilateral action that creates significant legal liability for the association and its members. Neither of them had known, when they resigned, that Connie was already living in my house. They found out when James called them Sunday. Frank Doss: "She moved in?" "For 11 weeks, James said. A silence. "I knew she wanted that property," Frank said. "She talked about it at board meetings, called it the jewel of the ridge, said it was wasted on someone who was never there." He paused. I thought she meant she wanted to buy it. I didn't think she meant this. James filed the criminal referral with the Watauga County Sheriff's Department and the District Attorney's Office on Tuesday, January 21st. 40 pages. The deed documentation, the tax records, the timeline from Dale's October contact through my January arrival, the Ridgeline contractor records, the mountain lock and key invoice, the fabricated authorization document, the internet service transfer records, the package delivery logs. 4 charges sought. Breaking and entering under North Carolina General Statute 1454, felony. The non-destructive entry by the locksmith, authorized by Connie and conducted on her instruction, constituted breaking and entering regardless of the method. North Carolina's breaking and entering statute does not require forced entry. It requires entry without authorization into an occupied or unoccupied dwelling. My house was a dwelling. Connie had no authorization. The entry was a felony. Felony trespass. Remaining on the property after entry without authorization. 11 weeks of continuous occupancy after an unauthorized entry on a property whose owner had not consented to her presence and was not aware of it. The remaining element of North Carolina's felony trespass statute was satisfied by duration and by the changed locks, which constituted an affirmative act to prevent the owner's return. Identity fraud under North Carolina General Statute 14-113.20, using another person's identifying information, specifically their residential address, without authorization to obtain services. The internet account transfer, using my address to establish a service account in her name, was a textbook application of the statute. Obtaining property by false pretense under North Carolina General Statute 14-100. The HOA contractor charges billed to HOA accounts on the basis of the fabricated authorization document. Connie had obtained $340 in locksmith services from the HOA's operating funds by presenting a document that falsely claimed HOA authority for the expenditure. The referral included a 5th potential charge flagged for the DA's consideration, wire fraud, based on the internet service transfer, which involved electronic communications to a service provider containing false representations about the account holder's identity and address. James had noted in the referral's cover letter, "The investigating party is a retired federal prosecutor with 25 years of experience in the United States Attorney's Office. The documentation package has been assembled to federal evidentiary standards." Detective Cartwright, the same investigator who had handled the initial deputy's report, called James on Thursday. "Mr. Whitfield, I've reviewed the referral." A pause. "This is thorough. My client has some experience with documentation. I've spoken with Terry Bosch at Ridgeline. He's cooperative. He understood he was acting on a client instruction and didn't independently verify the authorization. He's provided the original authorization document Connie gave him." Another pause. "The Article 9 citation she used, I had our county attorney look at the CC and Rs. He agrees with your reading. The provision doesn't cover adjacent non-member properties. We're in agreement on the legal analysis. I'll be contacting the DA's office this week. I expect charges to be filed within 30 days. James retained the property damage assessor on January 22nd, a licensed contractor from Boone, recommended by Frank Doss, who knew the local construction market, spent 4 hours at my property on January 24th. His assessment, lock replacement, all 4 exterior deadbolt systems, plus the associated door hardware Connie's locksmith had disturbed during the non-destructive entry process. 3 of the 4 had been replaced entirely with Connie's own hardware, requiring full cylinder and hardware replacement to restore original security specifications. Total, $2,800. Security camera removal and wall repair. 4 exterior camera mounting points, each with 2-inch hardware screws driven into the timber frame exterior. The timber was structural. The screw penetrations required inspection, filling, and exterior sealant treatment to prevent moisture intrusion into the frame. Total, $1,400. Internet service restoration, account transfer fees, service interruption charges, and the administrative cost of restoring the account to my name and address after the fraudulent transfer. Total, $800. Property inspection and remediation. Full inspection of all systems after 11 weeks of unauthorized occupancy. HVAC filters, plumbing fixtures, fireplace flue, exterior drainage. The fireplace had been used extensively without professional inspection of the flue, requiring a certified chimney sweep assessment and minor repair to the flue liner. Total, $3,200. And then, the occupancy damages. Watauga County mountain properties in the 4,800 square foot range, with comparable mountain acreage, rented at a fair market rate of approximately $8,500 per month at the time of the unauthorized occupancy. 11 weeks, 77 days, at the daily rate derived from the monthly figure. Unlawful occupancy damages, $23,375. Total documented damages, $31,575. James called me with the assessment summary. The occupancy damages are the foundation of the civil suit, he said, but they're not the ceiling. We have emotional distress, punitive damages, and the HOA's institutional exposure to build on top of this baseline. Build it all, I said. I want the complete picture. Victor, she told your property manager she'd use the property one way or another. She fabricated an authorization document, used the HOA's contractor, transferred your internet service to her name, and moved in for 11 weeks while you were in Charlotte. He paused. I've been practicing property law for 21 years. This is the most deliberate, premeditated residential squatting case I've seen. I spent 25 years prosecuting deliberate and premeditated, I said. The documentation holds. File everything. The 3 remaining board members discovered the full financial picture on January 27th. With Frank Doss and Linda Park gone, the Blue Ridge Summit board had been operating at 3 members since November. Gary Trent, Susan Cho, and a man named Phil Waverly, who had joined the board 8 months earlier and had the specific discomfort of someone who had agreed to help manage a community and had instead been handed a legal crisis. Gary Trent had called James's office on January 22nd, 2 days after the deputy's report had circulated through Watauga County's law enforcement channels, and had, inevitably, reached the ears of the adjacent HOA community. He wanted to understand the board's exposure. James had told him to retain independent counsel and to pull every HOA financial record from October through January. They pulled the records on January 25th. The locksmith invoice was already known, the $340 Ridgeline charge that had triggered Frank and Linda's resignations in November. But the full accounting revealed that the locksmith had been only the beginning. After Connie moved in, she had continued using HOA accounts and HOA contractors to support her occupancy. November 12th, Ridgeline Property Services, a maintenance visit to my property, billed as vacant property winterization check. Actual purpose, per Terry Bosch's cooperative account. Connie had asked him to inspect the HVAC system and check the fireplace flue. Cost, $420. November 29th, a cleaning service, Mountain Fresh Residential, a Boone area company that did periodic cleaning for several Blue Ridge Summit homes, billed to the HOA account for common area cleaning and adjacent property maintenance. Actual service, a full cleaning of my house after Connie had been in residence for 4 weeks. Cost, $380. December 14th, Ridgeline again, a property security assessment, billed to the HOA's December maintenance invoice. Bosch's account. Connie had asked him to install weather stripping on the rear door of my house and check the exterior drainage. Cost, $610. December 27th, another cleaning service visit. Cost, $380. January 3rd, a propane delivery to my property. I use propane for the backup heating system and the kitchen range. Connie had ordered a delivery billed to an account she had set up under Blue Ridge Summit's contractor billing arrangement. Cost, $1,740. January 9th, a final Ridgeline visit. Property check prior to owner return. Bosch had told James this visit had been explicitly about preparing the house for what Connie had described as the owner's anticipated January arrival. She had known I was coming. She had scheduled a cleaning and a maintenance check to make the house presentable before I arrived. And she had still been there when I pulled into the driveway. Final HOA maintenance visit, $600. Total HOA funds spent on the unauthorized occupancy of my property over 11 weeks, $4,870. The 3 remaining board members sat with that number and what it represented. Their HOA's operating account had been used, over 11 weeks, to fund the unauthorized occupancy of a private citizen's home by their HOA president. Every invoice had been processed through normal HOA channels, signed by Connie as president, categorized as maintenance expenditures, paid without secondary authorization because the HOA's bylaws allowed the president to approve maintenance expenditures under $2,500 individually. She had kept each invoice under that threshold. Phil Waverly. She structured the payments to stay under the authorization limit. The HOA's insurance carrier was notified on January 28th. Their attorney, a Raleigh firm that handled HOA liability across North Carolina, reviewed the full file over 48 hours and delivered their assessment in a conference call with the 3 remaining board members and their independent counsel on January 30th. The assessment was not comforting. Connie had acted throughout as HOA president. She had used HOA letterhead to create the authorization document. She had directed HOA contractors using her presidential authority. She had approved HOA expenditures using her authorized spending power. At every documented step, she had operated in her stated capacity as association president. The HOA's ability to disclaim her actions was limited by the degree to which her actions used institutional resources and authority. The fabricated authorization document, the contractor direction, the invoice approvals. These were not personal acts conducted independently of her HOA role. They were presidential acts conducted under color of that role. The carrier's attorney. The association has real exposure here. The question is not whether there is exposure, but how much and against what counts. Connie's defense, communicated through her personal attorney in early February, rested on 3 arguments. The first, abandoned property. North Carolina law, she claimed, recognized a property owner's rights as diminished when property was demonstrably abandoned, left unoccupied, unmonitored, and unmanaged for an extended period. She had entered a property that appeared abandoned and had maintained it in the community's interest. James's written response to this argument was the most direct thing he'd written in the case. North Carolina's abandoned property statutes apply to specific categories of property, primarily personal property, financial accounts, and safe deposit boxes, through a defined legal process administered by the state treasurer. There is no provision in North Carolina law that allows a private citizen to designate a neighbor's home as abandoned, enter it, change the locks, and occupy it. The process for addressing genuinely abandoned real property involves court proceedings, municipal authority, and documented attempts to contact the owner of record. Victor Ashworth had paid Watauga County property taxes in November 2024, 11 days after Connie's locksmith opened his front door. He had a recorded deed in his name with an unbroken chain of title. He had a property management agreement on file with the county. He had a Charlotte address on record with the county tax office. No legal standard of abandonment was remotely satisfied. The response closed with a single sentence. A property owner's decision to use their mountain home seasonally does not constitute abandonment under any applicable North Carolina statute, and Ms. Marsh's assertion to the contrary does not become more legally valid through repetition. The second argument, community interest. Connie claims she had been acting in the Blue Ridge Summit community's interest, protecting adjacent property values, preventing the risks associated with a vacant mountain property, fulfilling an implied community safety mandate. The community safety mandate, as Linda Park had told Connie in November, applied to member properties within the development. My property was not a member property. It shared a fence line with the development. Nothing in the Blue Ridge Summit governing documents created any authority, implied or explicit, over adjacent private land. The third argument, the HOA president's general authority. Connie claimed that her 6 years as HOA president and the general executive authority that came with that position authorized her to make judgment calls in the community's interest that might not be specifically enumerated in the governing documents. James addressed this in 4 words in his response brief: not on private property. Frank Doss and Linda Park had both saved their internal HOA communications. This was, as it turned out, the most consequential thing either of them had done. Frank had kept copies of board meeting minutes, email chains, and Connie's communications to the board going back 18 months. Linda had kept everything from her 2 years on the board. Together, they provided James with a documentary record of Connie's stated intentions regarding my property that was more damaging than anything the financial records contained. March 2023 board meeting minutes. Connie had raised the Ashworth property under the agenda item, Community Development Concerns. The minutes recorded her stating that the property was significantly underutilized and represented a missed opportunity for community enhancement. She had asked whether the board had any mechanism to approach the owner about community use or acquisition. Linda Park had noted in the margin of her copy, "I told her no, we have no authority over adjacent private property." September 2023 board meeting. Connie had raised the property again. The minutes were less detailed here. Frank had noted that the minutes for that meeting had been edited before distribution, with a section removed. Frank had kept his handwritten notes from the meeting. His notes recorded Connie saying the Ashworth property was the jewel of the ridge, and that it was wasted on an absentee owner who doesn't appreciate what he has. His notes also recorded one additional statement that had not made it into the edited minutes. Connie, at the September 2023 board meeting, "One way or another, that property should be part of this community's story." October 2024, 2 weeks before she called Terry Bosch at Ridgeline. An email from Connie to the full board, subject line, adjacent property status. The email noted that the neighboring property had been unoccupied since September, that the property manager appeared to be inactive, and that the board should be aware of community safety implications of extended vacancy. She had asked for board input. Frank had replied by email, "This isn't our property or our concern. We have no authority here." Connie had not replied to Frank's email. 2 weeks later, she had called Terry Bosch. James read me Frank's notes and the email chain on a Tuesday evening. She told the board in September 2023 that she intended to make the property part of the community's story, one way or another, I said. 14 months before she moved in. I thought about that timeline, the patience of it, watching the property for a year, raising it at board meetings, establishing the narrative of vacancy and underutilization, waiting for a window. And when the window opened, Dale's absence, my 4-month gap, moving with the specific decisiveness of someone who had been planning the moment. She told the board, I said. She said it in a recorded meeting. She documented her own intent. Her own board meeting minutes, edited or not, and her board members' handwritten notes establish that she had been specifically targeting your property for 14 months before she entered it. James paused. Victor, the fabricated authorization document wasn't improvised. The phone call to Dale wasn't opportunistic. This was a sustained plan executed over more than a year. That's premeditation. That's the word the DA is going to use. The Watauga County Grand Jury returned the indictment on February 18th. 4 counts. Breaking and entering under North Carolina General Statute 1454. Felony, Class H, carrying a sentencing range of 4 to 25 months. The charge is written that on or about October 31st, 2024, Connie Marsh did unlawfully and willfully break and enter a building occupied as a dwelling, specifically the residential property at the Ashworth Ridge address in Watauga County, without the authorization of the owner of record, Victor Ashworth. Felony larceny, theft of services. The internet transfer, the propane delivery, the 11 weeks of utilities consumed without payment or authorization. Services obtained through the use of another person's property and address, without consent. Obtaining property by false pretense under North Carolina General Statute 14-100. Felony, Class H. The charge as written, that Connie Marsh did knowingly and designedly, by means of a false pretense, specifically an emergency property security authorization document, falsely claiming HOA authority over adjacent private property, obtain services and property from Ridgeline Property Services and the Blue Ridge Summit Community Association, with intent to defraud. Criminal trespass, the 11 weeks of continuous occupancy after unauthorized entry, compounded by the changed locks that constituted an affirmative act to prevent the owner's return. Detective Cartwright called James the morning the indictment was returned. The DA wanted all 4 counts. He said the board meeting minutes were the clearest evidence of premeditated intent he'd seen in a property case in 15 years. James told me that evening. The minutes, I said. One way or another. In her own words, in her own board meeting. 14 months before she moved in. He paused. Victor, the DA doesn't lose this case. The only question is sentencing. James filed the civil suit in Watauga County Superior Court on February 20th. The demand was precise. Every figure documented, every category supported by the assessor's report, the financial records, and the case law James had spent 3 weeks assembling. Unlawful occupancy damages, $23,375. 77 days at the fair market rental rate for a comparable mountain property in Watauga County, calculated from the November 1st entry date through the January 16th removal. The rate, $8,500 per month, supported by 3 comparable rental listings in the Blue Ridge Summit area from the same period, obtained through Watauga County property records and short-term rental platforms. Property damage and restoration, $8,200. The licensed contractor's itemized assessment. Lock replacement, camera mount repair, internet restoration, full property inspection and remediation. Every line item with a receipt or professional estimate attached. HOA fund misappropriation, $4,870. The full accounting of Blue Ridge Summit operating funds spent on the unauthorized occupancy, the locksmith, the maintenance visits, the cleaning services, the propane delivery. Each invoice attached, each payment date confirmed by the HOA's own financial records, provided by the cooperative board members. Emotional distress, $85,000. James had assembled 3 comparable North Carolina Superior Court judgments involving unlawful residential entry and occupancy. Cases where courts had awarded emotional distress damages to homeowners who had returned to find their properties occupied without consent. The specific harm, arriving at my home after a 4-month absence to find it occupied by a neighbor. My bedroom furniture moved, my locks changed, my address used under another person's name. The violation of the specific security a person places in their home. Punitive damages, $170,000. The multiplier applied to the willful and premeditated nature of the entry, the 14-month planning period, the fabricated authorization document, the structured HOA payments kept under the individual approval threshold, the board meeting statement of intent. North Carolina's punitive damages standard requires proof of fraud, malice, or willful or wanton conduct. James had cited the board minutes, the fabricated document, and the structured invoice payments as evidence satisfying all 3 prongs. Attorney fees, to be determined at judgment. Total demand, $291,445 plus fees. Connie's personal attorney filed a response in early March. The response raised the abandoned property defense, the community necessity argument, and a new claim, that Connie had been acting in good faith based on her reasonable interpretation of the HOA's governing documents. James's reply brief addressed the good faith claim in 2 paragraphs. Good faith reliance on a legal authority requires that the legal authority actually exist. The Blue Ridge Summit CC&Rs do not contain any provision authorizing HOA action on adjacent non-member private property. This is not a matter of interpretation. The provision Connie cited, Article 9, Section 4, explicitly applies to member properties within the Blue Ridge Summit development. The Ashworth property is not a member property and is not within the Blue Ridge Summit development. No reasonable reading of that provision authorizes the actions taken. Good faith reliance on a provision that plainly says the opposite of what is claimed is not good faith. It is a description of the claim the party wishes were true. The civil case was scheduled for hearing in Watauga County Superior Court in June. The criminal trial opened in Boone on April 7th. Connie's defense rested on 3 pillars, as it had from the beginning. Abandoned property. The property had been unoccupied for months. The owner was absent and unreachable. The community faced real safety risks from an unmonitored vacant mountain home, and she had taken reasonable protective measures under circumstances that legally approximated abandonment. Community necessity. Her role as HOA president carried an obligation to protect community interests, and the neighboring property's vacancy represented a genuine threat to community safety and property values. Good faith. She had acted on her honest belief that the HOA's governing documents, reasonably interpreted, authorized her to take the actions she took. The DA began his response with 3 documents introduced as evidence. The first, Victor Ashworth's Watauga County property tax receipt, dated November 11, 2024, 11 days after the locksmith opened his front door. Payment current. Owner of record, Victor Ashworth. Address, the Ashworth Ridge property, Watauga County, North Carolina. A man paying his property taxes on a property his neighbor had already decided was abandoned. The second, the recorded deed. Unbroken chain of title. Victor Ashworth's name on the instrument of record. No lien, no foreclosure proceeding, no municipal notice of abandonment. None of the formal machinery that North Carolina law requires before any party can treat a residential property as legally abandoned. The third, the property management agreement between Victor Ashworth and Dale Hutchins, filed with Watauga County and bearing a current effective date. Dale Hutchins took the stand on the morning of April 9th. He was 61, a soft-spoken man who had managed mountain properties in Watauga County for 23 years, and who carried the specific guilt of someone whose moment of distraction had contributed to a situation he had not anticipated and could not undo. He had called me twice in January, after the removal, to apologize. I had told him both times that what Connie had done was not his fault, that she had targeted him specifically because she knew he was overwhelmed and distracted, and that the fault was hers. He told the jury what he told James. The property was not abandoned. It was under an active management agreement. The owner visited seasonally. He had been absent since September due to a family medical situation in Charlotte. The property was unoccupied, as it was every year during the fall and early winter. But unoccupied and abandoned are not the same thing, and a property manager on record is the specific documentation that distinguishes one from the other. The DA. Mr. Hutchins, was there ever any point at which you authorized Connie Marsh to enter this property? Dale. No. Did you ever tell her the property was available for occupancy? No. Did Mr. Ashworth ever authorize her entry? Mr. Ashworth didn't know she existed in connection with this property until January 16th. The board meeting minutes were introduced on April 10th. Frank Doss read his handwritten notes from the September 2023 meeting into the record, the Jewel of the Ridge statement, the wasted on an absentee owner statement, and the final sentence that had not made it into the edited official minutes. The DA read the sentence back for the jury. One way or another, that property should be part of this community's story. He let it sit for a moment before he continued. Ladies and gentlemen, Ms. Marsh told her own board, 14 months before she moved in, that she intended to possess this property one way or another. She then waited for a window. She then called the property's manager under false pretenses to confirm the vacancy schedule. She then prepared a document falsely claiming legal authority she did not have. She then directed a contractor to open a door she had no right to open, and then she moved in. He paused. This is not community safety. This is not good faith. This is a plan, executed over 14 months, to take a property that wasn't hers. The jury deliberated for 4 hours, guilty on all 4 counts. I was in the courtroom. I sat in the gallery with James beside me and watched the verdict delivered. I had been in courtrooms for 25 years, had watched verdicts delivered in cases involving wire fraud, mail fraud, public corruption, crimes that had taken years to build and days to try. I knew what a verdict felt like in a room. This one felt different. Smaller in scale, more personal in weight. The judge set sentencing for May 14th. Given Connie's lack of prior criminal record, the Class H felony sentencing range allowed for intermediate punishment, probation, community service, fines, rather than mandatory active incarceration. The DA had indicated he would seek active time based on the premeditated nature of the conduct and the sustained duration of the offense. James expected the judge to land somewhere in the middle. We walked out of the Watauga County Courthouse into an April afternoon. Cold still, the mountains holding their winter longer than the valleys. James had his briefcase. I had my hands in my coat pockets. Civil trial in June, he said. I know. Victor, the punitive damages. The premeditation is fully established now, convicted on all counts, the board minutes in the record. The civil jury is going to see everything the criminal jury saw. Good, I said. I thought about Ridge Run Lane, the 1.7 miles through the hardwoods, the creek bridge, the switchbacks, my house appearing through the trees at the final curve, the way it had always appeared, solid, specific, mine. I had been a federal prosecutor for 25 years. I had built cases against people who thought their position, their authority, or their certainty of their own righteousness made them untouchable. They were never untouchable. Neither was Connie Marsh. The civil trial was 6 weeks away. Judge Marion Ellerby sentenced Connie Marsh on May 14th. The courtroom was smaller than the one where the verdict had been delivered. A sentencing hearing draws fewer people than a trial. The drama concentrated into procedure, the gallery sparse. James was beside me. Frank Doss and Linda Park were 3 rows back. Dale Hutchins had driven up from Boone. The DA asked for active incarceration. He cited the 14-month planning period, the fabricated authorization document, the structured invoice payments, the sustained 11-week occupation, and the nature of the victim. A man who had built his career prosecuting exactly this kind of deliberate, premeditated taking of what wasn't yours. Connie's attorney argued for community service and a fine. First-time offender, no prior record. A woman of standing in her community who had made a profound error in judgment, born from genuine concern for neighborhood safety. Judge Ellerby listened to both sides without visible expression. Then she looked at Connie for a long moment before she spoke. Ms. Marsh, you are an intelligent woman. You were a community leader. You sat in board meetings and said out loud that you intended to have this property one way or another, and then you spent 14 months waiting for the window to take it. You fabricated a legal document. You directed a contractor to open a door you had no right to open. You changed the locks on a man's house and lived there for 11 weeks. She paused. This was not a mistake. It was a plan. 18 months, suspended. 3 years probation, a $15,000 fine payable to the Watauga County Court. Connie remained standing until the judge finished speaking and the gavel came down. Then she sat. The specific collapse of someone whose composure has been held by force of will for 4 months and has finally been released. I watched her from the gallery. She had been calm, almost administrative, on my front porch the day the deputy arrived. She had been calm through the indictment, through the trial, through the verdict. The calm was not innocence. I had known that from the moment I recognized her in my entry hall. It was the composure of someone who had convinced themselves their position was defensible. The judge had just told her it wasn't. James filed the civil judgment documentation on June 3rd. Total civil judgment awarded by the Watauga County Superior Court, $291,445. The HOA's insurance carrier settled separately, before the civil trial opened, on the portion of damages attributable to the HOA contractor use and fund misappropriation. The settlement? $94,000, funded through the Blue Ridge Summit Community Association's liability policy, covering the $4,870 in HOA funds misappropriated for the unauthorized occupancy, plus the HOA's proportionate share of the assessed damages, and a contribution to the punitive award. The insurance carrier's condition. The settlement was contingent on the Blue Ridge Summit Board adopting a formal governance reform package, a new written procedure for all expenditures involving adjacent or non-member properties, a requirement for full board approval of any authorization documents bearing HOA letterhead, and a mandatory legal review of any action involving property not within the development's recorded boundaries. Frank Doss had already been working on the governance package before the carrier asked for it. Connie's personal judgment, $197,445. It was a number that, for a woman whose primary asset was a Blue Ridge Summit home valued at approximately $480,000, represented a serious and lasting financial consequence. James had filed a judgment lien against the property the same day the Superior Court entered the award. "She'll have to settle the lien before she can sell," James told me. "It follows the property." "Good," I said. Blue Ridge Summit held its board election in late May, 3 weeks before the civil trial opened, the community moving forward on its own schedule. Frank Doss was elected president by unanimous vote of the membership. He called me the evening after the election. A brief call. He was not a man who used many words when fewer would do. "Victor, I want you to know something. What Connie did, the talking about your property at board meetings, the way she described it, the rest of us should have taken it more seriously. I knew she wanted it. I didn't think she'd do what she did. Frank, she made her own decision. You resigned when you found the invoice. You preserved your notes. You cooperated fully. That's what I needed from you." A pause. "All the same," he said, "I'm sorry it happened." "So is she," I said. "Now." I drove up to the mountain house the first weekend of June. Ridge Run Lane in early summer is different from January. The hardwoods fully leafed, the light broken into pieces by the canopy, the creek running higher from the spring rains. The road curves the same way it always has. The house appears at the same final left bend, through the same gap in the trees. I parked in the driveway and sat for a moment before I got out. The new deadbolts were solid. The camera system was mine. 8 units, exterior, transmitting to my phone and a local storage device. The timber frame exterior had been repaired where the hardware screws had been pulled, treated and sealed against the mountain weather. The chimney flue had been cleaned and inspected. The house was whole. Dale arrived 20 minutes later in his truck. He walked up to the porch where I was standing, and we looked out at the ridge line together. The long western view, the Blue Ridge receding in layers, the late afternoon light going gold across the upper slopes. "Victor," he put his hands in his jacket pockets. "I'm sorry. If I'd been checking the property like I should have." "Dale," I turned to look at him. "She picked the lock on a federal prosecutor's vacation home and moved in for 11 weeks. That's not your failure. That's her decision." He nodded slowly. The nod of a man who has been told something true and is working to let it replace what he'd been carrying. We stood there a while longer. The light was falling across the ridge, the shadows of the hardwoods stretching long across the upper slope of my property. The Blue Ridge Summit fence line, just visible at the western edge. "Victor," Dale said after a while, "that morning, before you called the sheriff, what made you park the truck across the road?" I looked down at Ridge Run Lane, where it curved into the trees and disappeared toward the county road below. 1.7 miles, one road in, one road out. 25 years as a prosecutor, I said. You learn when someone's about to run. Connie Marsh had been watching Victor Ashworth's mountain home for 2 years. She called it underutilized. She called it wasted. She said in a recorded board meeting that she intended to have it one way or another. When his property manager stopped checking in, she prepared a document, called a contractor, picked the lock, changed the deadbolts, moved in her furniture, and lived there for 11 weeks. Victor arrived on a Friday afternoon in January. His key didn't fit his own front door. He walked the perimeter. He called his attorney. He called the sheriff. And then he parked his truck across the only road out. Connie Marsh had one way to leave Ridge Run Lane. Victor made sure it was on his terms. 25 years as a federal prosecutor will teach you that.